The original United States Constitution left voting rights to the states, basically, didn't it? Prior to the ratification of the 19th Amendment, what were the most significant clauses concerning suffrage in our Constitution?
Yeah, that's a good question, because a lot of people, and a lot of Americans for that matter, don't understand that for the original Constitution, the Constitution that was written in Philadelphia in 1787, there's very little reference to the suffrage in that document. In fact, there's no specific reference that individuals in the United States actually had a right to suffrage. It was implied because in the Constitution, the states had the authority to determine who could vote, and in particular, the time, place, and manner of exercising suffrage. Now, as many are aware, this led to, if you will, a wide variety of regulations in regards to who could vote in the states. But by and large, Melton, the states determined that only white property-owning males could vote. Now, this changes with the 15th Amendment, because the 15th Amendment, which was passed after the Civil War, so this is known as one of the 3 Reconstruction era amendments, said voting could not be denied based on race or previous servitude. But that still left open the question of, would states allow women to vote? Okay, and as a couple of our other speakers will reference, okay, there was, if you will, some variation in that states, for instance, some in the western part of the country actually did allow women to vote. Okay, so when we get to the 19th Amendment, that said voting could not be denied based on sex. Then we had roughly another 40 plus year gap between the passage of the 19th Amendment and the 24th Amendment. Now, the 24th Amendment said that a tax could not be placed on exercising the suffrage. So that amendment eliminated one of those infamous Jim Crow laws or state constitutional provisions that placed a poll tax, a tax that you had to pay before you could vote. And then the last amendment that actually talks about suffrage in our Constitution is the 26th. Voting cannot be denied to anyone over 18 years of age. In effect, that is all the US Constitution says about the right to suffrage.
Oh.
Yes.
Okay, so let's talk about what happened after the 19th Amendment a little more. Which United States Supreme Court rulings have affected the vote since the passage of the 19th Amendment?
Okay. The Supreme Court has had a huge impact on the right to suffrage in this country. And in particular, the Supreme Court led by then Chief Justice Earl Warren, who was Chief Justice in the 1950s and the bulk of the 1960s, had a significant impact. And there are 4 Supreme Court rulings I'm going to briefly mention that impacted, if you will, the right to suffrage in this country. First, and this is probably the landmark decision in regards to voting in elections in the United States, was Baker versus Carr from 1962. The Supreme Court held in this case, Meldon, that election and voting disputes were no longer political questions that the federal courts would avoid and expect the political branches to address. Okay? And what was at issue in this case is a rule of justiciability. Should a court hear a case known as the political questions doctrine? The political questions doctrine basically is the Supreme Court or the federal court deciding that a particular legal dispute is best addressed by the political branches. And historically, the Supreme Court held that voting and election disputes were best handled by the political branches. But in Baker versus Carr, the Supreme Court, if you will, changed its mind. The court held that individuals, okay, that were challenging voting and election laws actually had access to the federal courts. And this was huge. This was significant because now individuals who argued a state law or a state practice that harmed their voting rights could go to federal court and get relief. Within 2 years, the Supreme Court took 2 more cases that had a significant impact on voting in elections in the United States. One was Westbury versus Sanders, where the Supreme Court held that House of Representative districts had to be roughly equal in terms of population. And again, this ended an historical practice seen in many states in this country where voters in rural districts, okay, their votes actually had more weight when counted than voters in urban districts, okay? Because again, if you gave a vote, okay, in a district that had a smaller population, okay, and in an urban area where there were more voters, but the districts were basically, equivalent, one district for one district, okay, rural voters actually had their votes mean more in terms of picking members of Congress. Mm-hmm. Likewise, in the same year, 1964, in Reynolds versus Sims, the Supreme Court held that state legislative voting districts had to be roughly equal in terms of population. So basically, if you combine, Meldon, Westbury, and Reynolds, this is where you get the one person, one vote standard regarding legislative voting districts. And this was significant, okay, particularly in regards to the value of minority voters, if you will, suffrage in picking members of legislative bodies. This was huge. One person, one vote. And it's still the standard, okay? The last case I want to make reference to is 2 years after that, 1966, a case that actually arose here in the Commonwealth of Virginia, Harper versus Virginia Board of Elections. The court held that the 24th Amendment's prohibition on poll taxes actually was constitutional. And the argument here that Virginia made was that the 24th Amendment explicitly contradicted, but did not say it was overturning the original Constitution's granting of authority to states to determine the time, place, and manner of elections. And the U.S. Supreme Court said, well, though it may not have explicitly overturned state authority, it explicitly prohibits a particular practice that was frequently used to discriminate against people of color and poor people, okay? Because if you could not afford the poll tax, you couldn't vote. Overall, these series of rulings sent, if you will, 2 clear messages. One, the federal courts could be used to maintain or protect the suffrage. And then 2, states no longer had free rein in regards to the suffrage, including discriminating against certain people or groups being able to exercise the suffrage.
Oh. Well, in light of that, why was the Voting Rights Act of 1965 passed? Why was it necessary?
The Voting Rights Act arose in 1965 in part because there was still the feeling in the country that, notwithstanding these Supreme Court rulings, the states would actively continue to discriminate against minority groups and the poor. Now, it also reflected the fact that, if you will, election results. For those of you who are watching this video, I'm going to, again, go back to the 1960s. In 1964, President Lyndon Baines Johnson won re-election. Moreover, the Democratic Party solidified their majorities in both the House and the Senate. President Johnson explicitly told his Attorney General, Katzenbach, to work with the House and the Senate to come up with the toughest voting rights law that they could craft. Because Johnson was of the opinion, and again, remember, he was from Texas, and Texas had a long history of voter discrimination against people of color and poor people. Johnson was of the opinion the political branches had to pass a law that explicitly, if you will, prohibited states from discriminating against people in regards to exercising the suffrage. The law, okay, had, if you will, two main provisions. The first was a very general provision. And it basically said that states were prohibited from discriminating against persons of color in regards to the suffrage. But the second, if you will, sections of the law had some rather controversial elements. One, there was a pre-clearance requirement, okay? The pre-clearance requirement basically said that any states, based on a formula created in this law that had a history of racial discrimination with the suffrage, had to either get clearance from the Justice Department or the District of Columbia District Court before they could make any changes regarding voting or elections within their state. And southern and border states who fell into the category of having to get pre-clearance, okay, were just outraged, okay? Because again, basically, if you go back to the original Constitution, the right of suffrage, the right to vote, was an authority given to the states to determine, okay, who could vote, how they voted, okay, etc. So for many of these states, okay, even if it wasn't about racial discrimination, this was about federalism. This was about states' rights. Now, Melvin, almost immediately the Voting Rights Act had significant impact. It increased the number of African Americans who registered and who actually voted. It eventually led to an increase in the number of African American elected officials in this country. It led to the creation of what's known as majority-minority voting districts, where a majority of the individuals within either congressional or state legislative voting districts are persons of color. That was significant, okay? And again, if you think back to those cases I mentioned just a few moments ago, you know, it wasn't until 1962 that the Supreme Court said that people could go to the federal courts and challenge, okay, those kind of voting districts that discriminated against people of color. And then, and this is pretty significant, it led to a realignment of who were affiliated with the Democratic Party and who was affiliated with the Republican Party. Because in many southern states, the Democratic Party, okay, which was, since Reconstruction, okay, primarily a white conservative political party, okay, began to attract a whole bunch of African Americans and other persons of color as voters. Mm-hmm. Whereas the Republican Party, okay, began to dominate in the South, okay, and this led to the kind of realignment that we see today, right? If you think about who are the primary voters of both the Democratic and Republican parties, you can, trace it to what happened with the Voting Rights Act and the Supreme Court rulings of the 1960s.
Wow.
Yeah.
Very interesting.
Yes.
So, since the suffrage is not an affirmative right enumerated in the Constitution, what other restrictions might the government impose on suffrage?
Good question. And I'm going to first, by taking a step back and saying this. If you think about the right to vote, because it's not explicitly stated in the Constitution, the right to vote in many ways in the US Constitution, okay, acts as a prohibition on the extent to which states may discriminate in establishing qualifications for suffrage. Okay, so, think again about the 15th, 19th, 24th, and 26th Amendments. The language of those amendments, okay, are explicit prohibitions on what states can do in regards to establishing who's qualified to exercise the suffrage. And again, this flows back to the fact that our original Constitution doesn't clearly, declare individuals have a right to vote. So, we still have, for instance, state provisions that prohibit convicted felons from voting. So we still have, a significant number of states who do that. We also know, for instance, that based on the Supreme Court's ruling in Bush versus Gore in 2000, that states must follow their state constitutional provisions and state laws regarding who can vote and how votes will be counted. And we also know, based on the Supreme Court's ruling in Shelby County versus Holder in 2013, that the formula that Congress used in the Voting Rights Act to determine which states needed pre-clearance was viewed or was deemed by the Supreme Court as unconstitutional. So now pre-clearance effectively has been negated by the Supreme Court. So, there are still, numerous restrictions that states place on voting, and they vary among the states. That's why voting in this country is so confusing to so many people. You move from one state to another, okay, and the qualifications are different.
Wow.
Okay. And if you talk, for instance, to outsiders or foreigners to the United States, they are just flabbergasted, by the way, and I've taught various international groups. They're just flabbergasted by the sheer range of different laws and regulations in place among the states in regards to who can vote, when they can vote, how they can vote. I mean, think about this, Meldon. This year, okay, this fall, a significant percentage of Americans may vote by mail. That will be completely different than the experience in previous elections.
Right.
And again, that's determined by states, right? Who can get a vote to mail in? Who might have to actually physically go to the polls? And this is all complicated because we are dealing with a pandemic. So,
Wow.
yes.
So would you say that the Civil Rights Act of 1965 is still effective?
The Voting Rights Act of 1965?
Yes.
It's effective in this sense. I mean, to be clear, the Supreme Court's ruling in Shelby County versus Holder significantly gutted an enforcement mechanism that required pre-clearance. Okay. Can individuals still go to federal court and claim that a state is violating their voting rights per the Voting Rights Act of 1965? Yes. But that's after the fact. By declaring the formula for determining which states had to get pre-clearance, effectively the Supreme Court, okay, made maintenance and protection of one's voting rights something that occurs after the fact, after an election occurs. So the overall impact of the Voting Rights Act has been decreased, okay, because of the Supreme Court's ruling in Shelby County.
Wow.
Yeah.
So, John, what do you see for the future of our Constitution?
In regards to voting rights?
Yes.
I think this year's election will give us some very clear signs as to what, if any, changes may have to occur with the right of suffrage in this country. The amendments we talked about before, and the amendment that was the focus of this year's Constitution Day for both VCU, but also Richmond Public Libraries, the 19th Amendment, held significant promise for an entire, if you will, a group of American citizens. But this year's election has the potential, okay, to be extremely complicated. We may not know, for instance, Meldon, until weeks after the election, who is the next president, which political party controls either the House or the Senate. You're talking about some generational differences in regards to the expectation of voting. So for instance, Meldon, you know, you and I have been voting at polls for decades.
Yes.
Okay.
We won't say how many.
Yes, right. But we interact with young people, okay, who do almost everything online, okay, or they do things via mail, right? You know, they order stuff online and then it gets delivered to their apartments, to their houses, okay, by various shipping companies, okay? We will have to take that into account. And states are going to have to make some changes. If more Americans are going to vote by mail, do we need to have as many polls? Do we need to keep polls simply because there are groups within our communities that rely upon going to physical locations for government services? So I think a lot of or many potential changes, okay, may arise because of this year's set of national and state and local elections. Because again, when groups in our communities, okay, want to protect or maintain the right to suffrage, it's only then do we get those changes. I mean, as our colleague Carolyn Eastman, talks about, for instance, in her video, the road to the 19th Amendment for the right to suffrage for women, okay, took a long period of time, okay? If you think about, for instance, the 15th Amendment, states not being able to deny suffrage to people because of their race or previous condition of servitude. Okay, that was a long time coming, right? And a lot of people were not allowed to vote. I mean, the basic core function of the social contract that underlies a democracy. So if you and I interviewed, okay, let's say early next year, I could probably answer your question with more detail simply because this fall's set of elections has the potential to really expose, okay, cleavages within American society as to how people want to exercise the suffrage.
Well, I guess we'll just have to wait and see.
Yes.
Well, thank you very much.
Well, thank you. I enjoyed our conversation today.
Thank you.
For those of you who want to follow up with some of the court cases and laws that I referenced in this interview, those cases include Baker versus Carr, 1962, Westbury versus Sanders, 1964, Reynolds versus Sims, 1964, and Harper versus Virginia Board of Elections, 1966. The amendments I referenced were the 15th, 19th, 24th, and 26th Amendments of the U.S. Constitution. And the law that we spent significant time discussing was the Voting Rights Act of 1965.
Yes, and all of those are available in the Richmond Public Law Library.
And they're also available at the VCU Cabell Library.
Yes.
So,
yes.
thank you.
Thank you. Bye-bye.
Bye.